All right. Hello, everyone, and welcome. This is our first workshop for the Big Bang, as well as the Little Bang business competitions that we run here at the Institute for Innovation and Entrepreneurship at UC Davis. My name is Nikki Peterson, and I'm the Senior Program Manager at the Institute. I've been on the team for almost 15 years, and I've managed this program for a long time. And so it's always exciting to see the new ideas come through and all the competitors put their best efforts into formulating their businesses and launching them from this program. So this is the intellectual property workshop. Vicky Lee is here from DLA Piper. She's a managing partner there, and her area of expertise truly is intellectual property law. So we're very fortunate that she's been working with us for quite some time. And as I mentioned earlier, this is an interactive session, so please put your questions in the chat or feel free to raise your hand, and we can do that from the beginning. So before I officially introduce Vicky, I want to be appreciative of our sponsors and show a slide here because we wouldn't be able to put these programs on without the support of our sponsors. So as you can see, I mentioned Vicky is with DLA Piper. They're listed at the very top there on the left. They have been our longest standing supporter of the Big Bang competition in particular, but also our other entrepreneurship academies as well. So we're very fortunate to have them do that for us. Something I also like to mention is that for those who make it to round 3 of the Big Bang, in April, we host, our DLA Piper hosts legal office hours individually for teams. And so that's something that the round 3 teams can take advantage of and get some free legal advice around their idea as they move forward. So keep that in mind. Also, just want to mention here, as far as next steps, I'll show this again at the end. But there's important deadlines for the Big Bang competition. March 3rd at 1 p.m. is the deadline for that. If you're looking to enter the Little Bang competition, the application is open until February 5th, but we can only accept 30 entries. And so we close registration as soon as those spaces are filled. We're about halfway there right now. So if that's something you're interested in doing, I encourage you to fill out that registration form. The deliverables aren't due until February 9th. And so you'll have time to do that, but the registration will at least secure your spot in the competition. And then we also have upcoming workshops. So those are listed here with dates. Joe D'Annunzio, our executive director, teaches those primarily. And then the QR code will also take you to our link tree so you can take a look at some of our other events and programs coming up. All right, so without further ado, I would like to introduce Vicky Lee. And if you would like to give a short intro, and then I'll get your slides ready and we'll get started.
Sorry, Nikki, you want me to do a short intro or?
If you would like to, that would be
Okay,
wonderful.
perfect. So hi, everyone. Nikki, it's a pleasure always to support the Big Bang competition for UC Davis. Not the least of which is because I'm a double Davis grad. So I did my undergrad as a history and econ double major at Davis, and then also stayed for another 3 years for law school. So very, very fond memories of my time at Davis. I'm a Northern California, native of Northern California. And so, lots of, like, as I said, lots of good memories of my time at Davis and happy to support Nikki and Joe and the Big Bang competition, every year. I think we're maybe going on 10 years now, maybe, Nikki?
At least, yeah.
Yeah.
Which is
Um,
awesome.
so as Nikki mentioned, I'm a partner at DLA Piper. We're a global law firm. We have about 4,000 lawyers around the world. We have offices in about 90 offices across 40 countries in the Americas, Europe, Middle East, Africa, and Asia Pacific. I am a technology transactions and commercial contracts lawyer. I'm one of about 500 IP and technology lawyers that practice in the firm. And, we have a very well-recognized IP practice. I often get asked, as I said, I'm a history and econ double major, so no science background. I spend my time drafting and negotiating contracts for some of the world's largest technology companies, as well as for folks like yourselves, budding entrepreneurs, serial entrepreneurs, ready to come up with the next big idea. And so you definitely don't need a technical background to do what I do, but you do need to have a basic understanding, and maybe sometimes a not so basic understanding of intellectual property law. And so that's the focus of today's presentation. Next slide, Nikki.
All right, so I'm going to go ahead and get this up and going. So here we are, and
We'll go to slide 4, which is the overview slide. So you're all here because this is part of the workshops that are associated with the Big Bang competition. I assume that at some level you all have some desire to start a company, and so we're going to be talking about what's the role of intellectual property as you're thinking about starting that new company. We're going to talk about why IP is important and some of the issues surrounding IP considerations as you're starting a new company. And then, because new companies often need financing, we're going to be talking about what investors are looking for in terms of IP issues as part of the fundraising process. So why should you all care about IP? This slide shows over time the value of tangible assets. And when I talk about tangible assets, I'm talking about equipment, real estate, physical assets that you can actually see and touch, and their value relative to intangible assets over time when we look at the largest companies that make up the S&P 500. So Nikki knows that my preference is to do this presentation in person, and we do it in person, a couple times a year. Here we're on Zoom, so I'm going to go ahead and see if this works. But if people can just chime in on the chat, what do you see when you look at this graph? Like, what do you see as a change over time in these highly valued companies? Anyone want to try to chime in on chat?
I've
The
got
increase.
increase.
Yep, the increase in intangible assets, the value of the intangible assets. That's exactly right. So when we look back at the kind of the far left part of the graph, you'll see that there's not much value in intangible assets. The companies and where they're generating revenue, it's mostly from their tangible or their fixed assets. And then you can see the gray bar, the gray part of the bars over time, that gets bigger. And that's the value of the intangible assets. And then that far right column, you can see, in 2018, that gray bar shows how much more value the intangible assets are relative to the tangible assets of the largest companies that make up the S&P 500. So a couple of nights ago, I went on the Motley Fool and then updated the list of the top companies as measured by market cap. And this is literally as of a couple of nights ago. So if you look at the top 5, you have NVIDIA, Apple, Alphabet, Microsoft, Amazon, and then, the number 6 is Meta. And then you see 9 of the top 10 are in the technology sector, and they've all outpaced the rest of the S&P 500 in the last 5 years. So you can see that the types of companies that are most valuable now are those where their core assets are built in, intangible assets, knowledge capital, intellectual property. And so that's why you should all care about intellectual property when you're starting your new companies, because you're seeing that's where all the value is built up. And then in the next slide, you can see just another depiction of the same trend. You can see that the intangible assets are 90% of the value of the S&P 500 companies. And the value of intangible assets in those companies from 1975 to 2020 have tripled. So you can see the global economy is moving away from an industrial focus where the value is based on fixed and intangible assets and moving more to a knowledge economy. Um, and what I see on the lawyer side, the legal side of things, is working with companies like John Deere and Caterpillar and BASF, companies that have historically been those that have their value more based in their fixed and tangible assets. They are actively looking for ways to either rebrand themselves as a tech company or looking for ways to manage their intangible assets. And oftentimes those two strategies go hand in hand. Um, my husband has worked for a long time with Visa. Um, Visa, I think most people think of them as a payments company. But if you look at all of their public filings, Visa refers to themselves as a technology company. And so again, that's another good example of why kind of intangible assets and intellectual property are super important, because it's about the innovation and the development of technology and the role that intellectual property plays in that in terms of building value for these companies. Okay, so now we talk about intellectual property. Intellectual property is international. It's inherently jurisdictional by nature. When we talk about the different types of intellectual property assets, there is no intellectual property um, that covers multiple jurisdictions at the same time. So for example, if I have a patent that's issued here in the United States, that gives me protection of the claims in that patent in the United States. There are certainly ways for me to protect the invention in other countries, and there are ways that I can do that on an expedited basis through various conventions and protocols that countries sign up to, so that the systems of the process for filing for a patent are similar. So it is, in some ways it can save you money. It can certainly save you time, but you do need to protect the invention country by country. Okay. Over the last couple of years, there has been one kind of notable exception to that and that is there now is in the EU a unified patent court. It is possible to get a single patent that covers multiple countries in Europe. But that, again, is a relatively new occurrence over the last couple of years. And that only helps you with respect to being trying to protect an invention for that might be covered by a patent in multiple European countries. It does not help you on the trademark front or the copyright front. You do need to, if you want your trademark protected in multiple countries, you do need to register the trademark for protection in the countries that you're interested in. And then in enforcement, if you believe that someone is infringing on your patent or if someone is using a trademark without your permission, you do have to enforce that on a country by country basis. So that is one reason why thinking through the protection of your intellectual property portfolio as part of managing the growth and the business strategy of your company is super important because you can imagine it can get very expensive as you're going out and securing trademark registrations in multiple countries and then having to monitor the use of those trademarks and possibly enforcing and suing for trademark infringement as an example in multiple countries. And we'll talk a little bit later about why it's important to align the IP protection strategy with the business strategy. So what I like to do here on the next slide is talk about some common types of intellectual property in the US. And so those four main types of intellectual property protection: patents, copyrights, trademarks, and trade secrets. So we'll go through each of those individually. For patents, some people don't, but patents are actually authorized by the US Constitution. The patent right is a right granted to Congress to encourage inventors to come up with new ideas. It gives inventors the exclusive right to their inventions for a duration of 20 years from filing. That's for a utility patent. There is something called a design patent, and the duration for that type of patent is 15 years from the date of filing. The example I like to give to distinguish between a utility patent and a design patent is some of you might remember the one of the early Apple computers, I think it was the iMac. It's kind of like an egg-shaped kind of computer. That egg-shaped design was covered by a design patent, but all the inner workings of how the computer operated, there were many utility patents that covered the operations of the iMac computer. So you can think about the inner workings of the computer, and that is the utility patent. If you think about the TVs that are in your living rooms, all the chips that are in those TVs, many of them are covered by utility patents. If you pull out your user manual or the user guide, that the instructions that came with your TV, it's very likely in the back of that somewhere there's a bunch of numbers that list the US patents that cover various features and functionality that make up that TV for you. So that is another example of a utility patent. And so what do patents give you the right to do? Patents, the exclusive rights afforded to owner of a patent is the right to make the invention, use the invention, sell the invention, import the invention, or have the invention made by a third party. Those are the exclusive rights granted to the holder of the patent, but those can be licensed. Okay. Again, what can be protectable are inventions, designs. There's also something called plant patents, and being from Davis, that's probably something that is very near and dear to the folks on kind of the ag college. We as a firm, we don't do very much with plant patents, but they are available to protect plants that are that may be new kind of genetically altered plants. You'll see I've highlighted here in red that the inventors need to be human inventors. And why is that important now? It's important because everyone's talking about AI. And so, in all honesty, the the patent law hasn't caught up to AI yet, because it was written on the assumption that humans are inventors. But we do know that it is possible for artificial intelligence to come up with new inventions. And so, though the patent law has not changed officially, at least in the U.S., the U.S. Patent and Trademark Office back in 2024, they did issue guidance on when something is patentable, when there is inventorship that's been assisted by AI. There It's not that AI assisted inventions are categorically unpatentable, but it depends on the amount of human contribution involved. And for now, the human contribution needs to be significant. Okay. So that's why, at least for the time being, human inventorship still you should consider a requirement for being able to file for patent protection. Similar concerns on the copyright front, especially on,
Vicky,
yep.
there's a question in the chat before you go to copyrights on patents.
Does
So
the inventor
the
get to
question,
renew the patent every 20 or 15 years? No, um, there's no renewal per se, but you can certainly make additional claims and expand the scope of the patent protection. But the idea is that we want innovation to continue to advance. And so, it's not as if like a patent, the patent owner has a monopoly, in perpetuity. So a good example of that are the drugs, right? The reason why we have generic drugs is because all of a sudden the patents have expired on some of the drugs. And so that's why we're able to have generics versus brand name drugs.
thank you.
Okay. So on the copyright front, so again, human authorship is for now super important, especially because there's so much opportunity for AI generated works. Okay. The copyright protection is available for AI generated works so long as there's human contributions. And prompts themselves are not copyrightable. So what is protectable by copyright? We don't protect the idea. It has to be the work of authorship. So it is something that is reduced in writing. So, a play, a piece of music, software code, photographs, web pages, databases. Those are all examples of copyrightable works of authorship, but merely the idea of something is not protectable by copyright. And registration is not required. You can have a copyright and a valid copyright on a work of authorship, but you don't actually have to file a piece of paper with anyone in order to have that copyright be valid. The reason people register their copyrights is if they want to enforce the copyrights. If you're wanting to sue someone for copyright infringement, a good example of that is a book. That book needs to be the subject of an actual copyright registration in order for you to be able to sue and collect damages. The tech companies that I work with often do not. Some people find this surprising, but if you think about it, it kind of makes sense. So most tech companies do not file copyright registrations for their software. The reason for that is generally twofold. One, tech companies generally don't like to sue their own customers. And so if you think about a software company, they're making money by having their customers use their software. And so if they're suing for infringement, they're generally not wanting to sue their customers. Okay. The other reason why they don't generally file for register their copyrights is the pace of innovation is so fast that filing for a copyright registration on software often ends up being kind of not relevant because the software ends up getting outdated by a new version. And so the likelihood of a company enforcing their copyright rights on a piece of software that's outdated is pretty low. And so kind of though copyright registrations are not difficult to do, it does take someone some time to go to the effort of putting the filing together. And there's just not a lot of value to it if you're not planning on suing, or if the likelihood of suing means you're probably suing on an outdated piece of software. Okay. And again, on the AI generated content, it does need to be for works that have some level of human contribution. The work of authorship, you could have an AI generated portion of a work and then the human generated portion of the work. And the combined work can be the subject of a copyright registration, but the AI generated content, to the extent that it's something more than something de minimis, that AI generated portion of the content will be excluded from the copyright registration. So again, for right now, the still on human. And so for those of you who are, programmers, lots of tools out there these days that are used for generating code to maybe fix bug fixes. The advice that we're giving to our clients is you need to make sure that those bug fixes are pretty de minimis in nature if your expectation is to have a valid copyright on the code. Okay. Next. Oh, I see a question. How can we have a copyright and not register it? What's the process? So there's no process for having a valid copyright. A good example is, so long as you've taken an idea and reduced it to a tangible medium of expression, that work of authorship is protectable as a copyright. The interesting thing about patents and copyrights and trade secrets is they work differently, right? And so Nikki and I, if we're writing software code, so long as we don't copy from each other and we just happen to come up with the exact same software code, each of us could have a valid copyright. Okay. Works of authorship, copyright infringement happens when there's copying involved. So long as we don't copy from each other and we work independently, we could each have valid copyrights on essentially the exact same piece of software code. That is not the case with patents, nor is it the case with trade secrets. With patents, it's whoever comes up with the idea first, and then whoever files the patent first. For trade secrets, we're jumping ahead a little bit, but so trade secrets are any non-public information that provides a competitive advantage by virtue of that information being kept as a trade secret, and that steps are actually taken to maintain that information as a trade secret. So if I have a piece of software code, call it source code, that I consider a trade secret, if Nikki gets a hold of that source code and ends up copying it, I can sue her for trade secret misappropriation. Okay, I may also be able to sue her for copyright infringement, right? So in that sense, trade secrets and copyrights are distinct from patents. And one kind of threshold issue that um, companies often need to consider is when they've come up with an invention, are they going to seek to patent that invention, or do they want to maintain it as a trade secret? Um, the reason that's important is trade secrets, theoretically, so long as you continue to take steps to protect that information as a trade secret protection can continue in perpetuity. The question that was asked before about patents, about the duration and whether or not they're right, you do not get to maintain patent protection in perpetuity. And in fact, if you choose to file for patent protection, the application is typically published anywhere from 12 to 18 months, at least here in the US, after filing the application. And that's before the patent actually ever issues. The patent process can be very, the patent process can be very lengthy, but the publication of the application happens because, again, remember, patents are the rights to patents are granted by the Constitution, and the founding fathers wanted to encourage innovation. And so the idea behind publishing the application is to allow the public to be able to see what the invention is, how the invention works, and then to consider is like, what's the next generation of that invention, right? How do they continue to innovate? How do they come up with something new? So there's no trade secret protection available for an invention that's covered by a patent, because once the application is published, it's out there, it's public. And trade secret information has to be non-public information, provides an economic issue of not being publicly known. The example I like to give about a classic trade secret, a classic example of a trade secret is the Coca-Cola recipe. Coca-Cola recipe's been a trade secret. Original Coke, not new Coke, but the original Coca-Cola recipe has been a trade secret for 100+ years. Why is that the case? Because very few people within the company know what the actual recipe is. Rumor is that there's no more than two people in the company who actually know what the formula is, and what goes into making Coke. And it's under lock and key, and those two people are not permitted to fly on the same plane, when they're traveling. So again, that is kind of anecdotal. Maybe it's kind of myth and lore, but those are the steps that the Coca-Cola company has taken to protect the recipe as a trade secret. And that's how they have been able to keep it a secret for as long. And so long as they continue to take those steps, and they're able to show that they have taken those steps to maintain this recipe as a trade secret, they'll be able to continue to have that trade secret protection in perpetuity. What can be a trade secret? So, it could be a method, it could be pricing information, it could be a customer list. What works is not the only thing that could be a trade secret. So if you think about, I call it negative information. So knowing what doesn't work can be as valuable as a trade secret as knowing what does work. And so if you think about, if you have two companies, they're both kind of working on a similar drug to address an illness. One company figures out that the path the R&D path they're going down is not going to result in the outcome that they're looking for, and they discover that early on, and they're able to change course. in their R&D strategy, the fact that they know that early on, that can be a very valuable trade. That can be a very valuable trade secret for that company. And not sharing that information with their competitor and having their competitor continue to go down a path that the first company knows is not going to lead to a successful outcome, that can provide the first company a huge advantage. And so companies often forget that, again, what I call negative trade secret information can be just as valuable as knowing what does work. Okay, next question. Next series of questions relate to how we protect IP when pitching and everything. We're going to get to that in a second. So if Ata, if you could just hold that question, give me a little bit, and then we'll get there. How can we have a copyright? Okay, we already covered that one. All right. Next category of information. Actually, before I go to trademarks, a couple of other points on trade secrets. Trade secrets, remember I talked about IP protection being country by country. Here in the US, trade secret protection is actually state by state. So we do have a federal trade secret law. The US passed the Defend Trade Secrets Act in 2016 to provide federal protection for trade secret information. But there's also the Uniform Trade Secret Act that's been adopted by 49 states. Other than 49 states and the District of Columbia, the one state that hasn't adopted the Uniform Trade Secret Act is New York. And New York, instead, they've adopted trade secret protection using the restatement of torts. So slightly different definitions as to what constitutes a trade secret. Remember, I talked about trade secrets being information that's not publicly known, provides a economic advantage, but you also have to take actual steps to maintain its trade secret nature. The restatement of torts requirement does not have that kind of effort requirement. So long as you can show that it is, provides an opportunity to gain an advantage, you can have trade secret protection in New York. Okay. So that's on trade secrets. We'll talk about NDAs in a little bit. Going to turn really quickly to trademarks. So trademarks, and then when I talk about trademarks, I also include service marks and logos and brand names. So what are trademarks? They identify the source and the quality of goods and services. Trademarks generally provide a protection for 10 years from registration. So long as you're renewing so long as you're using the trademark in the country where you have the registration, you can continue to renew the mark. Okay. You don't have to have a registration on file to have a trademark. You can have common law rights. But again, if you're doing lots of marketing under your company's name or under a product name, we do recommend that you go to the trouble of actually registering the mark, because it gives you additional protections vis-a-vis third parties that common law rights don't have. Again, the AI is an issue here now for companies as they think about trademarks. I just had this issue pop up this morning. We have one client. I'm going to come up with because I can't disclose any client confidential information. So let's say we have a client whose name is Los Altos Software Company. They are conducting business under the name of Los Altos Software Company. Turns out there's another company out there that's in a very similar business, but their name is Software Los Altos. So what do you all think is the likelihood of confusion in the marketplace between those two company names? High, low? What do we think? High? Pretty high likelihood of confusion, right? Very high. Yeah, Miriam, you're right. Very high. And so in that situation, our advice to the company would be hey, before you spend a lot of money investing in a whole sales and marketing campaign around the use of this mark, you might want to check to see if the mark is actually available for you to register, and if some other company out there might be using a similar mark that could create this likelihood of confusion. The reason why that's important as more and more companies are using AI in their business is the use of AI in marketing is getting to be very commonplace. And so when you're asking an AI algorithm or AI platform to come up with a new tagline or a new logo or a new trademark for a new product you're about to launch or a new company that you're thinking about starting, you have no way of knowing where ChatGPT, for example, has pulled that trademark from. And so it might seem like a really snazzy, jazzy trademark, but our recommendation is that you go to the extra effort of checking to see that that trademark is actually available for use. And we're seeing lots of instances where companies are just relying on, these generative AI tools to come up with seemingly interesting marks that they don't actually end up being able to use. When you're thinking about trademarks, you want trademarks that are what we call arbitrary in nature. Trademark protection is not available for marks that are descriptive. And so if you think about like escalator or Kleenex, um, those used to be trademarks, but they have gotten to be so descriptive over time that the value of those terms of as a trademark have been lost over time. And so, again, if you think about trademarks as being the source of identifying the source and the quality of goods and services, you want those marks to be as arbitrary and distinctive as possible. So if you think about Apple computer, right? When they first started as a company, you would never have associated a computer company with the Apple logo, and so that was a very distinctive mark at the time, right? And so same thing with like the Nike swoosh. You wouldn't associate that with the shoe, and so when you're thinking about trademark protection, thinking about marks that are distinctive and arbitrary as opposed to being descriptive of what the company does or what the product is, that's going to give you the strongest level of trademark protection. Okay, next slide. So yep.
One question, at what point can we say we have something that needs to be protected as IP?
At what point can we say, so it depends on what type of intellectual property you're talking about, because you have these different categories of intellectual property, right? So, it's going to differ from whether it's software code to like a customer list or a chip design, like a semiconductor chip design. For patents, there are certain requirements for something to actually be patentable. And so often you will hear that, well, software is not patentable because that was a business process. And so that's where having, an experienced IP lawyer to walk through with you, what is the invention? Does it have, utility? Is it against public policy? Inventions that don't serve a public, don't have kind of a usefulness, are not going to be patentable. An invention that is not new, not novel. That's the legal standard. That's not going to be patentable. Remember, there has to be something that is new. And then the third factor for patentability of an invention is that it has to be non-obvious. So if you are just coming up with an invention that anyone kind of schooled in the same field that it would have been easy for them to come up with, that's not likely not going to meet the non-obvious standard. It really needs to be something that's new, novel, that is patentable. Okay. That's different from, say, wanting to get copyright on a book, or if you're Taylor Swift, getting the copyright on your songs, right? So the Taylor version as opposed to, the Big Machine version of her songs, right? And so, and again, it's as soon as you write something down in a tangible medium of expression. So, when Taylor comes up with the song, as soon as she writes down the lyrics, those lyrics on the piece of paper, she can say that that is protectable as a work of authorship by copyright. Okay. But those lyrics are not going to be subject to trade secret protection because she's going out and singing the songs, right? So it does depend on the type of IP protection you're looking for.
Right.
Let me see, there's trademarks state by state or the entire US. You can get a state registration on trademarks. It's not very common. Typically, companies just get a federal level trademark registration. Um, Let me see. Okay, non-competes, we're going to get there. So
Great.
we're talking about um, when do you start your new venture? Oftentimes we get that people want to continue to get a steady paycheck, right? But at the same time, you are working with one employer, you may be, a budding entrepreneur and thinking about your next venture. And so how do you make sure your IP is protected in that case? The reason why this is an important consideration is many of you, if you've ever, many of you may be still in school, but if you have worked, for a company, you may have been asked to sign an agreement with your employer that has confidentiality obligations that you have to agree to. You agree that you won't disclose the employer's confidential information. You agree that anything that you develop while you're employed is owned by the employer. Okay. So those agreements can make it difficult for someone to work for one company at the same time that they're trying to come up with, working on their next on their next company. And so in order to make sure that the intellectual property that an employee develops for the new company is owned by the new company, our recommendation is having that separation of time between different stints of employment can be super helpful. But again, we understand that that's not always possible because you want that steady paycheck. And so how do you protect the intellectual property? Um, Generally in California, and in most states, what you do on your own time um, is yours, so long as you are not using your employer's equipment, so long as you're not using your employer's confidential information or trade secret information. And so what does that mean? If your employer issues you a laptop for your work, use your own personal laptop on your own time if you're thinking about starting your next company. Don't have anything on your work laptop. Keep records to show that everything was done on your own time. Everything was done on your own laptop. You weren't using, you weren't sitting in the lab after hours and using the lab equipment at your employer's facilities, right? Um, and so all of that is very important to create that separation between what's owned by your current employer and what you may own for your next company. And then when you are actually ready to leave your employer, that agreement that you sign also obligates you to leave everything behind with that employer. So that's another reason why you want to do everything on your own personal laptop and not on your work laptop, because you're going to have to leave that work laptop behind. You should not be taking any notebooks. You don't want to be taking any, certainly not downloading any code. If you're in a software company, so you have those obligations that you need to abide by in your agreements with your employer. And so, that separation again is super important. And when we talk about going and raising money from outside investors, this is one of the issues that they're going to be very focused on. And the reason for that is they want to make sure that the intellectual property that is that a company that they're investing in says that they own, that the company actually does own that intellectual property. Okay. Um, does this apply to, for example, resources you use from the university? So good question. Um, so we talked a little bit about the agreements on the university side. So there are some unique requirements for universities. So, and this applies to undergraduates, it applies to graduate students, professors, um, postdocs. So UC Davis, like other universities, have IP policies. Those IP policies can range in terms of how restrictive they are. Um, as a general matter, universities um, want to own everything that their students and their professors develop using university resources. And so that could be the lab, it could be a laptop that the university issues. It actually doesn't even need to relate to any equipment or resources that the university provides. So we often run into a situation where professors serve as advisors for for tech companies, especially if you think about universities that are in kind of big tech hubs. So here in the Bay Area, Stanford, Berkeley, Davis, I kind of think of Davis as an extension of the Bay Area. Lots of professors are asked to serve as advisors on companies or serve on the board of directors. The time that they spend with those companies and what they contribute to those companies, that can also be subject to the university's IP policies. And so when we see that an advisor or a director or even a part-time employee is affiliated with a university, we always want to check to see what the university's IP policy says about IP ownership. A good example of this is, several years ago, we were representing a client that was a spin out of Georgia Tech. They were a tech company incubated at Georgia Tech. And Cisco was going to acquire this company. for, several hundred millions of dollars. Um, and this is all kind of public knowledge, so I'm not disclosing anything that I shouldn't be disclosing. But what happened was when they were incubated at Georgia Tech, um, there was a professor involved, and Georgia Tech has a fairly restrictive IP policy. So their IP policy at the time provided that Georgia Tech owns everything that their graduate students and their undergrads and their professors were involved in developing, even if it's on their own time, unless they received a written waiver from Georgia Tech. So now we're on the eve of an acquisition, and the Cisco is doing their due diligence. They run across this situation where there's a Georgia Tech professor involved with a company, and then they look at the IP policy and they ask if the company had received a written waiver of that policy at the time the professor was involved. Well, unfortunately, this was before we represented the company, but the company did not have the written waiver. They didn't even know about this issue about having, Georgia Tech having an IP policy. And there was no way now that they could go back and ask Georgia Tech for a waiver. And so you can imagine that, Cisco coming in and acquiring a company, and they're worried about Georgia Tech claiming ownership of some of the intellectual property that this company purports to own. Like that was a problem. And so any guesses as to what the outcome was of that situation? Okay. So the outcome was there was a reduction in the purchase price, and by a pretty significant amount. And so the reduction in purchase price, what does that mean? That just means that the shareholders of the company ended up getting a lot less than they thought they were going to get, right? And so that's a good example of why thinking through the IP issues, when you're starting a company is super important, because you never know when a problem may come back to bite you. And, if you think that you're going to get a big payday on an acquisition, that's a very bad time for an IP issue to pop up and have that bite you in the behind. Okay. Um, so IP issues for founders. So we talked about kind of founders going off and starting their own company. But now if you kind of look at it from the other perspective, the founders now has a company and they're going out and hiring people. How do they make sure that the people that they hire, um, whatever they're developing, ends up being owned by the company? So there's a difference between hiring employees and then hiring consultants and contractors. So in the US and most companies around the world, because we're all parties, most countries are members of the Berne Convention, so we treat copyrights similarly. Um, an employee who creates a work of authorship in the scope of their employment, um, that work of authorship is automatically owned by the employer as a work for hire. We don't have to have a written agreement in place with employees, for the employer to own copyrightable works. Okay. There are some nuances when it comes to patents. And so for that reason, we still like to have employees sign written agreements. But if you are primarily a software company and you're expecting that the software is going to be mostly protected by copyright, and trade secret, then you can rely on the fact that you can rely on this work for hire doctrine, that the copyrightable works of authorship are automatically owned by the employer even without a written agreement. That is not the case if you're hiring someone as a consultant or a contractor. The consultant or contractor is going to own their own development, unless you have a written agreement with that consultant or contractor where they assign ownership to the company. And why is that important? Again, we see lots of times when companies come to us and they've hired a consultant or a contractor because they don't have the cash to pay someone as an employee. They don't want to pay an employee minimum wage to do development. So they hire someone as a consultant. Maybe they pay them, a small kind of de minimis amount. And, they assume that because they've paid for the development, that they own the work product that's created by the consultant or contractor. Unfortunately, that is not the case. You do need a written agreement. And so, you do need to think about when you're starting a new company, the capacity in which you're hiring people and making sure that you have the right documentation in place. Okay. Um, Okay, next slide. Non-competes. So someone noted that yes, non-competes are not enforceable in California. Um, the non-competes are enforceable on a state-by-state basis. California has a public policy against enforcement of non-competes. We don't want to restrict people from, having mobility in terms of their employment. It applies to employees and contractors. A couple of years ago, there was a proposed Federal Trade Commission ban on non-competes, but that is, at least for right now, that is not enforceable. There are states in the U.S. where non-competes are enforceable, but there's kind of a spectrum of enforceability. If you have a non-compete that goes on forever, covers, all, many jurisdictions around the world, that's probably going to be determined, held to be unreasonable, an unreasonable restraint on employment, because it's too broad. So even for those states that enforce non-competes, the restraint needs to be somewhat reasonable. It should be limited in time. Anywhere from, 1 to 5 years is pretty common. Should be limited in terms of, kind of field. If someone wants to move from being a software developer into, doing something with food, they should be able to do that, right? And so, thinking through non-competes, if you are outside the state of California, and then the scope of what might be enforceable is important to consider. And, we recommend that you consult with an employment lawyer to come up with the right form of agreement. Non-solicits. So non-solicits are, you can't go and, when you start a new company, you can't go and try to hire, your former colleagues at your prior company. Those types of agreements are not enforceable in California, unless the goal is to protect trade secret information, right? And so, like the wording of the contract there is going to be really important, to ensure that the restriction is not overly broad so that it is not enforceable. And then the other thing is, you want to make sure that to the extent that you signed in an agreement with your former employer, that you remember what your obligations are, that you are subject to ongoing compliance with those obligations. You are not free of those contractual obligations by virtue of no longer being employed. So we have lots of situations where we have individuals who leave an employer, they go start another company, and for some reason they've taken some confidential information, or they're alleged to have taken some confidential information from their former employer, and then their former employer sends them kind of a very stern, nasty gram reminding them of their obligations. And so those obligations continue to be valid. And so you need to keep when you're starting your new company.
And Vicky, we're about 20 minutes to go, so just wanted to give you the heads up on timing.
Okay, great. Thanks, Nikki. Um, okay, so IP protection for a startup. We've covered a little bit of this already. So you need to make sure that when you're starting your own company, you own the intellectual property. Um, you want to make sure you have the right agreements in place, whether it's for an employee or a consultant or a contractor. Those agreements should include confidentiality provisions so that your trade secret information is protected. Um, Remember, trade secret information in almost all states in the United States, you need to take steps to protect that information as a trade secret. So what does that mean? You make sure your employees understand that they need to erase things off the whiteboard when they have after they're done with their meetings. You have appropriate firewalls and email security in place. Your wireless communications are encrypted. So again, all all important to show that you're actually taking steps to maintain your non-public confidential information as a trade secret because that's what's required to have trade secret protection. Um, we talked about the difference between patent and trade secrets and where to obtain IP protection and registering or not. So now we're on the non-disclosure agreements. So, if you're talking to prospective investors, how do you introduce your company? Um, what I like to tell clients is you can talk about the what. So what is it that you're doing? But what you want to try to stay away from is the how. How are you trying to solve the problem, right? So, describe what your product does, but not how your product, um, how your product works, because that is the secret sauce that you want to make sure that stays protected. Okay. You can talk about the competitive landscape, but you keep the discussions around the business model at a high level because how you might tackle the business model or how you might structure the business model could still be trade secret information. This is especially important when you're talking to prospective investors. So investors, especially the very sophisticated ones, the classic venture capitalists that are on Sand Hill Road here in Menlo Park, they won't sign a non-disclosure agreement. So the only protection that you have as you're talking to um, prospective investors, maybe competitor companies, is you taking active steps to monitor the nature and type of confidential information, the nature and type of information that you are sharing, because even if you were to have a non-disclosure agreement in place, um, actually enforcing that non-disclosure agreement requires time and money. It requires hiring a lawyer to go out and either sue for trade secret misappropriation or send a nasty gram to a company, and that is expensive. And so what we tell founders of companies is we understand you're super excited about your new business, but you are your best protection for keeping your intellectual property safe. The other thing is, if you are looking at signing a non-disclosure agreement, there are different types of non-disclosure agreements. And everyone lots of people assume that just because a non-disclosure agreement is mutual, that the information of both parties is equally protected. And what I tell clients is you actually need to make sure that when you're entering into what seems like a bilateral or mutual agreement, that it actually is mutual, because oftentimes the nature or the importance of the confidential information that's being shared is not the same for both parties. And so while on paper, a non-disclosure agreement may seem very balanced and very kind of even-handed, you really do need to think about what is the information that you're disclosing, what is the value to your company of that information, and how is that value kind of what's your assessment of that value relative to the information that you may be getting from the other company. Oftentimes, two parties will enter into a mutual non-disclosure agreement, but there's only one company disclosing any confidential information. So that's a reason why you really need to think hard about what you're signing. Is the agreement really as mutual or bilateral as you think it is? Okay. Protecting your IP. So we talked a little bit about this, carefully guarding your information, making sure you enter into appropriate confidentiality agreements when you can, and then where you can't, just monitoring, keeping track of the nature of the confidential information that you're disclosing. We have a whole separate presentation on the details and the nuances of confidentiality agreements. Confidentiality agreements are not complicated agreements. They're often only 2 or 3 pages long. That is also, I think, one of the issues with confidentiality agreements, because they don't seem to be very complicated legal documents. I see lots of situations where clients don't spend a lot of time thinking about it or reading it, and then they end up with problems later on. So if you walk away from this presentation with one kind of nugget, is don't simply look at the length of a document and make a determination as to how important it is based on length. You really do need to think about what is the substance of the agreement, even if it turns out to be a very short non-disclosure agreement. Okay, on strategic IP planning, we talked a little bit at the outset about the importance of strategic IP planning. Remember, IP is jurisdiction by jurisdiction, right? Country by country. It would be impossible, even for the largest companies, to think about IP protection in every single country of the world. And so this is where aligning the IP strategy with the business strategy is very important. So what do I mean by aligning the business strategy with the IP strategy? If you think about the business strategy as, where am I going to generate the most revenue? Where are my priority markets? Am I going to generate most of my revenue in the US, or am I going to generate most of my revenue in Asia? Where is my manufacturing going to take place? Answering questions like that is going to help inform where you want to or should protect your intellectual property. So if you think back to patent protection, one of the exclusive rights granted to a holder of a patent is the right to make, use, and sell, right? So if I have a chip that is going to be manufactured in Asia somewhere, and it's going to be sold in the US, I may not need to have protection for that chip in Europe right away, okay? Or in Latin America, anywhere, right? So, but because I'm manufacturing the chip in Asia, I do want to have patent protection where that chip is manufactured. And if I'm selling the chip in the US, I want to make sure that I have patent protection for that chip here in the US. So that is an example of where thinking through the business strategy can inform the IP protection strategy. Similarly, on the trademark front, If I'm only going to be selling here in the US, then I might not need to think about trademark registration, at least not right away, outside of the US. Okay. And so that is a way for companies to manage their budget, their legal spend, in a way that continues to maintain their IP protection, um, in a manner that aligns with the growth of the business. Okay. Um, Next slide, and then we talk about licensing options. So we've talked about different types of IP rights. We've talked about how a company might secure those IP rights, from employees and contractors. So, when we talk about licensing, that is about how companies might get additional IP rights that they don't own. So, getting a license from a third party. And it also relates to how a company might monetize their intellectual property. So, licensing the intellectual property, as a way to generate revenue, whether it's from license fees or royalty payments, or allowing others with the exclusive right to sell in a particular geography, or maybe manufacture in a certain field of use, covering a certain invention, right? And so how those license agreements are structured, can be very important in terms of how a company generates revenue, from its intellectual property. I know we're running a little bit short on time, so I'm going to touch really quickly on, raising money. So what do investors ask when they're conducting due diligence? So due diligence is the process of, vetting a company. If a company is either getting acquired, or they're trying to get investments from, an investment from outside investors. That acquiring company, the investors, they want to make sure that they know what is happening with a company. If a company says they own all of these patents, and they have all of these agreements that are going to generate all of this revenue, and that is what's justifying the value of the business, for the investors, and why, or why a company might want to acquire this business. There needs to be a process to verify that all of that information is true and accurate. And so that is the due diligence process. It's really, you can think about kind of looking under the covers of, looking under the hood of the car, right? Making sure that everything is working as the company says it's working. And so, investors will look at the key agreements. They'll look to see if a company might have given away any of its intellectual property, inadvertently or intentionally. It will look, for example, at all the consulting and contractor agreements. Remember, because those are different from the employee agreements, we need to make sure that if there's consultants and contractors engaged for development of IP, that we have written agreements, that assign ownership from the consultant or contractor to the company. Lots of times, companies don't have their house in order, and so they don't have those agreements in place. And that the due diligence process is when these problems pop up. And so, what we tell clients is the goal is always to have your I's dotted and all your T's crossed, as you form the company, as you grow the company, because you don't want to have to go back and fix those problems when an investor or an acquiring company has identified that problem for you as part of the due diligence process. Even if you have those problems, you want to be out in front of them, and be proactive about trying to fix them, because the worst situation, the worst situation is when you have someone else who identifies a problem that you didn't even know about. And so that is when investments often fall apart, and valuations end up getting decreased, acquisitions fall apart, and shareholders end up losing money. So you want to try to avoid those situations. Um, and then, we talked about kind of here on the next slide, ownership. Um, Open source software is also oftentimes something that is a focus for due diligence. How is artificial intelligence used, for trade secrets? Has the company taken measures to protect its trade secret information? And on the patents here on the inbound and outbound, what licenses might have been put in place that might create encumbrances on the IP portfolio. So, and then the last slide is, additional questions that might be asked about trademarks and data rights, and then some of the more adverse terms that might show up in an agreement, a commercial agreement. So let me see if someone, for example, entering a public pitching competition and their early stage, how careful should they be? You mean something like the Big Bang competition? Um,
Possibly, yeah.
yeah, possibly. Um, I mean, I don't think that there's ever a situation where you can be too careful. I recognize it is a fine line to walk between getting a prospective investor or a prospective kind of judge for a competition to be excited about your idea or your company, um, and then, but at the same time protecting the intellectual property, right? So again, I fall back on touching on what is the problem that you're trying to solve, at a very high level. How are you planning on solving it? So I think, Nikki, as part of the Big Bang competition, there's a separate workshop that deals with kind of pitch materials and like the deck and the executive summary, right? And
Correct,
so
yes.
and I don't know if that workshop has already happened, but the typical presentation is made up of a couple of different components, just like an executive summary is. And so, what the judges typically are looking for is what is the problem solve? Is someone else trying to solve the problem? Is someone else already trying to solve the problem? Because if there's a lot of competition for solving that problem, then it makes it harder for you to distinguish yourself as a company, right? And so understanding the competitive landscape for the market is often a kind of a critical element of the presentation. And then how do you plan on solving it? And then the potential rate of return. Like, I think when you're looking at investors, I mean, they're very focused on ROI. And so I think you can talk about your potential solution without getting into the details of how that solution works, right? So it's about understanding the target market, and understanding kind of your proposed solution, and then the potential rate of return. And I think you can do that without disclosing kind of the crown jewels for your venture.
That's fantastic. Well, thank you so much, Vicky. A huge round of applause for getting all of that information into a very short amount of time for us on this workshop. We really do, appreciate you being here and going through all of that important material. So we're getting ready to wrap up here, and just quickly before we do, I want to again just show this slide that not only applauds our great sponsors, but then most importantly, next steps for what's coming up. Again, the due dates for both the Little Bang and the Big Bang, the registration code for our upcoming events, And then this was actually the first workshop. We always kick it
Okay.
off with Vicky because she's the best. But then we do our following workshops, and they're all listed here with the times. You can use this QR code to go to Startup Tree and register for those so you get the Zoom links for the upcoming workshops. So
And
thank you
my,
all.
and my
Yes.
contact information is at the, I think, slide 26. And so, I'm happy to have off the record. I don't think that's cheating for the competition, right, Nikki?
No, because
Um,
you're not facilitating the competition, so they can call you all they want.
okay, so I'm happy to have conversations, and that's all free of charge, at least initially, right? And so yeah, so you'll find on slide 26.
That's great. Such a valuable resource. Well, thank you all for being here. I look forward to future workshops and seeing you at the competition. Have a good
Thank-
day.
All right, thank you.